Hello and welcome to the Season 1 finale of Plants to Plants Hemp Processing Seminars by Sci-Fi Systems. Sci-Fi Systems brings industrial extraction and processing technology into the future, and Plants to Plants brings top-tier experts to the table to inform viewers about what it really takes to go from concept to completion on a hemp processing plant. Thank you all so much for being here. The season has been a massive success in so many ways, creating conversations and learning moments that we hope are truly valuable for you. We want to thank everyone that came to any episode or supported in any way, and we cannot wait to share what we have in store next after a short hiatus, but more on that in the future. So before it's time for that, we will get into the session we've been waiting for. Today's episode is Carving the Right Path, Legal Solutions and Market Perspectives, an interview and discussion with Kight. This discussion is focusing on strategic topics to help your team navigate its roadmap. Topics covered include the regulatory landscape and prospects of regulatory changes, future of the national marketplace, internationalization of the market and global forces, and how to address challenges such as COVID facing the market, as well as much, much more. Our guest this week is Kight, a cannabis business law attorney who lives in Asheville, North Carolina, and a close ally of Sci-Fi Systems. He represents legal cannabis businesses throughout the country and the world, and is the author of the Kight on Cannabis Law blog, a popular blog that discusses evolving legal issues affecting the cannabis industry. Rod is also an author of a book and has a numerous amount of accolades. If you're unfamiliar with him, this is your first time seeing him, you're absolutely in for a treat. And if it is not, well, then welcome back for another discussion. We are going to be hosted by Emmett McGregor, Sci-Fi CEO, and we want to remind everyone to ask questions using the Q&A module on your screen. Really anything pertaining to the topics and the things that are popping up that maybe you'd like to ask these experts, please feel free to let it go. We definitely want questions, and there's going to be a dedicated time for them at the end. Once again, all past episodes are available for view on YouTube and over on our website, so go ahead and check those out. I am going to begin bringing up our presenter and our host momentarily. Thank you guys so much for being here, and I will pass things off to Emmett and to Rod.
Great, thank you,
Thanks,
Edwin, for the introduction. And welcome, Rod. Really excited to have you on. I know that the legal and regulatory landscape is where I think a lot of people start with their process of developing a hemp processing facility and a new hemp business. Worth noting that while you've worked in the legal, medical, and recreational cannabis arena, you also work in the industrial hemp space as well extensively. So I think maybe the place we can start is, when we think about starting off a journey into a hemp business, it's probably best to understand where we stand as a country and as a business community with regards to rules, regulations, and law. I guess the place to start these days is probably the Farm Bill. I guess that's 2018 Farm Bill. What can you tell us about where that situates us? Are we in a place where, we think things are stable legally? What does it look like from now going into, say, 2025?
Oh, wow, that's great. Well, Emmett, it's good to be here. Thanks for having me. It's always a pleasure talking with you and Edwin. And so, yeah, I mean, I think that's really the place to start. Where are we situated right now? And now is a very unique time. I mean, I guess every seems like every time with respect to cannabis is a unique time. Every year seems like another 10 years has gone by and we're in this new space. But with respect to hemp, it's really unique because we are in a transition period. Hemp was originally legalized, removed from the Controlled Substances Act in 2014 with the passage of the 2014 Farm Bill. Every several years, the Congress will pass a new farm bill. And in 2014, it included a very, very short provision regarding industrial hemp. And when industrial hemp, which was defined as cannabis that has no more than 0.3% delta-9 THC, grown pursuant to a state's pilot program, that hemp was not a controlled substance. There was actually some debate about that. That's probably not worth going into now, but and so that started us off. And most states, I think it was 40, although that may not be the exact right figure, over time have enacted pilot programs. And so hemp has been grown in the United States for several years. And the place we are now is that at the very end of 2018, a new farm bill came out, the current one, and it was broadly reinterpreted what hemp was and its scope, and it defined it as the plant cannabis sativa with no more than 0.3% delta-9 THC, and all of its cannabinoids, extracts, derivatives, isomers, and so on and so forth. And so that legalized hemp in a broader way. And to get to the point, which is where we are right now, those state pilot programs from 2014, many of them are still in effect. And the reason is because the Farm Bill said, well, the USDA is going to issue a rule. And when it does, 12 months from the issuance of that rule, it will go into effect. And states can either be governed directly by the USDA, or they can submit programs and plans to regulate hemp production within their borders. And a lot of states have done that. A lot of states have had their hemp plans approved. A lot of states haven't done that. And so that is set to expire, at least currently. COVID changes everything. We don't know if the deadlines can be extended, but as of right now, the 2014 Farm Bill pilot programs that are still in existence are scheduled to sunset, meaning they're going to end at the end of October of this year. So we have right now this unique situation where we have hemp that's being grown under the 2014 Farm Bill pilot programs. We have hemp that's being grown under state plans under the 2018 Farm Bill, and then we're going to have hemp that's going to be grown pretty shortly, potentially directly under the purview of the USDA. So it's a fascinating time, a lot of meat on the bone for lawyers to get at, that's for sure.
The key thing there that I'm taking away, of course, is that there's a patchwork of regulations. If states haven't filed a specific state plan for regulating the industrial hemp industry, will they be defaulting to the federal guidelines as the regulations, or will hemp be legal to cultivate and process in those states? Or where do they go if they don't have a state plan but they do have a pilot program?
That's a great question. Well, if a state that does not have a plan and its pilot program has a sunset, those growers will be applying directly to the USDA and being regulated directly by the USDA. And as clear as that may sound, it's actually still some legal issues, because you have states right now, post 2014, that Farm Bill has expired. States are no longer creating new pilot programs, but states are creating statutes, and they're defining hemp, and they are regulating production of hemp under new state statutes. But those state statutes are not in and of themselves a plan that is proposed to the USDA. They can be packaged as a plan and submitted to the USDA in certain respects to be approved, but there are going to be states where they don't have a plan that's approved by the USDA, but there are hemp laws on the books that regulate the production of hemp. And so this is a classic question of what we call federalism, where you have state laws and you have federal laws, and usually those federal laws will preempt or override contrary state laws, but not always, and not necessarily in all respects. So we're going to have what may even amount to more of a patchwork. Well, the state law says this, but it's not approved by the USDA. What controls? And so that's a novel question as well.
So I guess probably the most stable bet in operating a business is going to be in a state that has filed for a state plan, or in a state that has no existing rules and is just defaulting to USDA jurisdiction. Well, that
yeah.
is that,
I think that's right. And there's not that many states now that don't have laws on the books. I think there might be one, or I think Mississippi might not have any laws at all on the books, and maybe one other. So yeah, the plans that have been submitted and approved, that's the most stable, because you say, okay, well, here the state has complied with federal law. It's submitted a plan. That plan has been approved. The USDA says it's a go, and so you can operate under that plan. There's lots of sort of sub issues about this. So, for example, what if you're a state that has a pilot program, and that pilot program has licenses that go for 3 or 5 years, so you renew them every several years. You get it a year ago, and then now the pilot program sunsets and terminates. Are you automatically do you have a license to grow under the approved plan to the USDA? Yeah, maybe, maybe not, depending on how it's written. Or do you have, what about a state that doesn't submit a license? You know, does your license apply to when you're working directly with the USDA? Maybe, maybe not, probably not. So just more issues. But to your point, I think that's exactly right. The most stable thing is operating in a state where there is an approved plan.
And does the USDA, do the USDA guidelines address a lot of specific processing rules and regulations? I know there's a heavy emphasis on the cultivation side, but are there any changes from what we saw early on in most of the state pilot programs that were well developed, like Colorado and I guess the Carolinas came in fairly early, as well as Oregon. Is there a well-established framework, or do we think that the USDA is going to have a lot of follow-up rulemaking that's going to go on specific to the processing sector?
Well, that's an interesting question, Emmett, because processors are sort of in a little bit of a no man's land when it comes to the rules. So the USDA is the agency that's primarily charged with the duty of enforcing and regulating under the Farm Bill, and including the hemp provisions. And the USDA issued what's called the interim final rule, what we refer to as the IFR, back in around Halloween of last year. I remember blogging about it on Halloween night. I felt it was kind of, but so, and it absolutely deals with production, which mostly means cultivation. And there's some language regarding transportation of hemp and whatnot, but it really doesn't deal in any to any great degree with processing. And in fact, I asked the hemp chief at a conference just a few months ago about a specific issue having to do with processing, which is the work in progress hemp extract, or what's hot hemp as sometimes it's referred to see if the USDA had a position on that. And he told me, he said the USDA does not have a position on that issue, which again is a processing issue primarily, because the USDA only regulates production. And he said that is something that the FDA would regulate. Well, as anyone who follows this industry knows, the FDA has not regulated hemp and CBD to any great degree, other than with respect to CBD specifically as in its use as a dietary supplement or in a food. So right now there is sort of this area where we've got production is regulated by the USDA in a rule, and we've got the FDA's position on CBD, which comes from hemp, and it's kind of fleshing out. And if we want, we can talk about the FDA. But then processing, there's not really a whole lot there. And so certain state laws and plans are developing rules, as you indicated. Oregon and Colorado have some progressive and sophisticated rules regarding processing and hemp handling and all these sort of post-harvest issues, but the IFR and the USDA do not.
So yeah, I do definitely want to dig into the FDA's role in this process, but I see that we have a question from the Florida Hemp Council. It looks like they're asking about an extension filing for CFR 9900 implementation. That's pretty specific, but maybe you know off the bat what they're referring to there. I'm guessing that has to do with the USDA federal rules coming into place.
Yeah, well, sure. Well, I think, and again, COVID, everything is all about, extensions and pushing this, that, and the other out. And, I don't want to sort of in this forum go about say, well, here's how you go about getting an extension. I'd be happy to discuss that privately, but I think that it's likely we will see some extensions being granted, and that while that is helpful in that we can see how we can kick out the deadlines, and in this industry every few months we see new developments and new understandings of the issue, and I think there's some real benefit to having an extension to propose a plan. By the same token, where does that leave things now? Does that also extend the 2014 pilot programs or not? So I think that is likely that we can get extensions. The mechanics of that, probably not appropriate for this forum, and it certainly could be helpful. But as in this industry and a lot of issues, it could also cause some more confusion.
Right. So I guess the follow-up there is contact an appropriate attorney, be it Kight Law or otherwise, to try and find the best pathway for your specific circumstance, because it is definitely going to be dependent on what are the state rules, how are
Yeah.
you in compliance with them? Are you defaulting to the USDA, or is there some other plan in your state as to how that process is going to look like for you?
Yeah.
So, but to go back to the question of the FDA. Oh, go ahead. I think I had a glitch there, but
Oh, we
to go
might have
back to
had a glitch. Yeah, yeah. So, yeah. And by the way, I apologize. I'm going to try not to attorney it and say, well, that's a legal question. But sometimes, the specific facts are pretty important. The specific state or agency or participant that's asking the question, and sometimes those questions will need to be sort of addressed in private and confidential setting.
Mhm. Yeah, absolutely. And that's key for this talk. Of course, Rod will draw the line where he needs to. He can't offer specific legal advice to anyone. We are doing an educational program here with a general review of the lay of the land in law and regulations. So if you have specific questions where it will require a legal opinion, we will, of course, defer to private conversations. So to go back to the FDA real quick, the FDA as it is, we know that they have approved CBD inclusive pharmaceutical drugs at this point for orphan drug status. They've gone through clinicals, thinking of Epidiolex and Sativex primarily. I've heard that there may be also some Canadian pharmaceuticals in process of approval. What can you tell us about where that sort of sets the bar for CBD products, and especially for manufacturers of CBD products? And where do you think that puts us? What are the sort of risks and benefits of looking to manufacture CBD inclusive or hemp derived ingredients in the market right now?
Yeah, sure. So I think you make a good point about the hemp derived. And so CBD itself is with respect to its controlled status and the Controlled Substances Act, it is a controlled substance or not based on its source. The same compound, different sources. If it's sourced from marijuana, it is a controlled substance. It's a Schedule I controlled substance, the same as marijuana. On the other hand, that same compound that's derived from hemp or some other non-controlled substance is not a controlled substance. And that's called the source rule, which I developed a few years ago and has been adopted by the industry and agencies as well. In fact, a colleague of mine, Bob Hoban, wrote an article today in Forbes that actually discussed the source rule extensively. And so I appreciate him continuing to help educate the world on that. So from here on out, we're talking about hemp and hemp-derived CBD, to be clear. The current FDA policy is that CBD is not legal for use in supplements and food because it was the subject of a drug application, as you indicated, Epidiolex. This is called at least colloquially, the drug exclusionary rule or the IND exclusion rule. And what it means is that when an article, that's the term that the statute uses for a compound, when an article has been the subject of a clinical drug trial and it was not previously marketed as a dietary supplement or a food, well, then that same article cannot be a dietary supplement or marketed as a food. And there is some, I've heard conversations and talked a lot about with people over the years who say, oh no, CBD was marketed prior to the Epidiolex trials, but there hasn't been a whole lot of substantial evidence put forth. So the FDA has taken this position, and by and large, the industry has as well, that CBD is subject to the IND, the drug exclusion rule. And so that informs the FDA's policy. It says, well, you cannot use it as a food ingredient. You can't market it as a dietary supplement. There has been a lot of focus on getting this changed in various different forums. And I actually made some notes here. So if it looks like I'm reading, it's because I am. And these are very recent things that have happened. But before I talk about that, I'll say about a year ago in May of 2019, the FDA held its first and only hearings on cannabis compounds, and it was focused primarily on CBD. I testified there, and you heard sort of the range of opinions across the board about CBD, but everyone, I think literally everyone that testified from whatever position they were coming from made the point that the FDA really needs to step in and regulate this. And the FDA hasn't done a whole lot to date. So more recently, on June 16th of this year, the Council for Responsible Nutrition filed a citizens petition with the FDA requesting that the FDA establish a regulatory pathway to market CBD as a dietary supplement. This was focused not on food, but as a dietary supplement. The next day, June 17th, the I think it's four agencies, the Food Policy Consumer Federation of America, the Center for Science in the Public Interest, and Consumer Reports, it's three, wrote a letter to Congress urging Congress to reject any attempts to force the FDA to move quickly to regulate CBD. Back in late May, early June, there was news that the White House was reviewing, as of this moment, a federal plan for marijuana and CBD research, and that the FDA had submitted some draft guidance on that issue to the Office of Management, the House Office of Management and Budget. And then on June 23rd, just a couple days ago, the Natural Products Association had a webinar where they asked the FDA to set up a safe level of daily consumption for CBD products, and said we've been doing this for 3 years trying to get the FDA to set that up. And apparently several state agency regulators were there and chimed in and said, no, the FDA needs to do this. So there's a lot of movement in that direction. There's a bill you and I were discussing right before before we went live. There's a bill in the House right now that would override the drug exclusionary rule expressly and say, no, CBD is appropriate for as a food and ingredient and as a dietary supplement. And then many states have adopted their own rules. We have this federalism issue in the United States where both the federal government and states issue laws, and some states have taken the FDA position, and some states have gone absolutely contrary to it and said, Colorado and Virginia most notably, and said CBD can be used as a food ingredient. So regulation and how it's going to be regulated is just moving apace, and there's a lot out there. From a practical standpoint, CBD being used in food has been at least tolerated by the FDA. The FDA has sent out a number of enforcement letters to companies that sell CBD products, but has focused primarily on making medical claims, and that's prohibited, because as soon as you make medical claims about an article, that article is going to be treated as a drug, as an unapproved drug specifically. So the FDA has been pretty aggressive about that, but with respect to the mere use of CBD in food, it hasn't been so aggressive. And it's also stated that CBD can be used in cosmetics, provided again that they don't make medical claims. So that was a mouthful, and I apologize. I just kind of wanted to at least sort of set the context for where the FDA is and where we are with regulation of CBD.
I know that's very helpful. And when we look at the market overall, so the cosmetics, in this case, just so we're clear on what that specifically means and where the FDA stands on it, does cosmetics cover any topical application of CBD, so long as it doesn't make a claim to specific symptom relief? Or is there a more narrow interpretation of cosmetics that folks should be looking at when they think about cosmetic use of CBD as approved by the FDA?
Yeah, good question. I think for our purposes, the use of the term topical or cosmetics can be used interchangeably. The big issue being that you're not making medical claims, and that is to say that you're not saying that CBD can mitigate or relieve or cure a disease, or even that it can affect the structure or function of the body, which is what's called a dietary supplement type claim.
And a big thing there, of course, is that cosmetics typically manufactured in GMP facilities as a minimum requirement. When the USDA sort of deferred to the FDA to regulate, the baseline regulations of the FDA would seem to apply for each category of product. And across the board, that means that consumer products need to be GMP manufactured in a GMP, federally approved GMP facility, it would seem, for cosmetics. And of course, right now it sounds like there may not be officially a pathway to nutritional supplement being marketed, but that would require CGMP 111 approval and of the facility and the process to be able to manufacture that. So sort of trying to predict where the FDA is heading, it may have big impacts as to how people might manufacture their facility and how they might build their facility for manufacturing and how they might try and get certified. One question that I've gotten from some folks is, okay, if we move all the way through CGMP approvals, we get approved to manufacture a nutritional supplement product in anticipation that the FDA may allow, say, hemp extract to be inclusive products to be marketed as a nutritional supplement. Do you know if they then manufacture products within that facility but do not market them as nutritional supplements, if that's allowable? That is to say, they can manufacture, say, a cosmetic product that makes no claims and they don't state on it that it's a nutritional supplement. Is that allowable in an approved CGMP 111 type facility?
Yes. I think generally speaking that it would be allowable. And a lot, maybe even most of the CBD products that are on the market now are not manufactured in CGMP compliant facilities, and that's changing rapidly. And certainly from a practical standpoint, if you're a manufacturer, that's where you need to be headed. I mean, that's where it's going. This industry was born in a lot of ways in kitchens and whatnot, and those days are over. The manufacturing, any sort of botanical product that you see on the shelves or that you order online have to meet these standards, and hemp-based products are no exception.
Absolutely, and some people might hear that word and be a little bit scared, but it's key to remember that GMP for food manufacturing, not talking about supplements, but for food and small batch cosmetics manufacturing, that can include things like commissary kitchens, which get approved as being a GMP manufacturing environment. But the big thing for the individual manufacturer is going to be making sure the documentation, the bookkeeping, the batch records that are needed to stay in compliance with GMP rules. Because those commissary kitchens out there that allow, for example, a lot of farmers market type foods to be manufactured, those are approved. As long as they were officially approved for that type of use, you assume, check with whoever's operating that commissary kitchen, and make sure, of course, that they know you're using hemp derived ingredients in their facility.
Right.
You don't want to get in a dispute over that. But that could be a way to get a legal manufacturing environment for the product side. Now, when we look at ingredients, which is our big focus at Sci-Fi Systems, obviously you've got to be prepared to deliver an ingredient that can be compliant with GMP when it goes into consumer products. I wonder if you might comment on your interpretation or general industry trends about when does that GMP tracking need to start in ingredient manufacturing? If I'm a processor, I want to send my ingredients out, sell them to manufacturers that are using good manufacturing practices out there. Is there a good rule of thumb? Does my entire facility, everything from extraction, filtration, solvent recovery, distillation, potentially crystallization, although we might want to follow up on isolate CBD as being a product where we're heading there. But just assuming, you have a full process line, does every one of those steps need to be GMP, or is there a rule of thumb about, where that GMP tracking needs to really start?
I think they all should be, and I think because one of the key pieces of GMP is this ability to trace it back to the batch. If there's a recall of a product and they need to isolate the particular ingredient or ingredients or to analyze it for what cause someone to be sick or whatnot, they need to be able to trace all those things back, and very quickly. And so I definitely recommend that SOPs encompass all of those processes that you just discussed.
Right. So, and typically we always recommend work with a GMP compliance consulting firm that will help to guide you through what it takes to implement. Again, there's some physical infrastructure requirements, but a lot of it is about documentation, record keeping, batch records, and then going through the official approval process from a federally recognized GMP auditing body. So
that's exactly right. Yeah.
Big part of the project of planning is, like Rod just said, if you're getting into the business now, we got to assume that all those FDA rules are going to apply. Now, one thing to keep in mind here, we talked about CBD, we talked about Epidiolex and the opinion there around CBD. What is CBD in that definition, and is there a differentiation between, say, a hemp extract or what's sometimes called broad spectrum or full spectrum extract and CBD in the FDA's interpretation? Where is that line?
It's a great question. One of my favorite issues in the industry, and there's a lot of them, is this issue about what do we mean by CBD? If you look at the FDA website and the letters that have been written, the FDA specifically says CBD. But in fact, a lot of hemp products are made with CBD and other cannabinoids, terpenes, flavonoids, and just the full brew of hemp constituents. And so we talk about a broad spectrum or a full spectrum, but all of these are extracts of hemp. And so the drug exclusionary rule that I talked about earlier, which is the reason that the FDA's position on CBD is that it can't be marketed as a food or dietary supplement, is based on the specific article. Well, the article in the Epidiolex test trials was, CBD isolate, purified CBD. Well, what about a hemp extract where we have these other phytonutrients? My legal position, I've written on this, is that is not covered by the drug exclusionary rule. There is some argument on that side. In fact, there was a recent trademark case decision that denied a trademark to a company, I won't mention names, based on the fact that it was in violation of the drug exclusionary rule. This is a major generalization, by the way, but the company said was actually making a hemp extract product. So there's a little bit of negative case precedent out there. I don't know that it's dispositive in situations outside of the trademark context, but the idea is that a hemp extract, even though it may contain CBD, is not the same as CBD. And there's some really interesting issues, and I think I can sort of tease them out by a reference to another case, and that has to do with red rice yeast. So red rice yeast, for those that don't know, is a sort of a natural product that's been around for a long time. And it's a product that's used for many health issues, but also to lower cholesterol. So the companies have been producing red rice yeast for decades. Back in the 80s, I believe it was Merck, but don't quote me on that, isolated the primary compound that was responsible for lowering cholesterol, called lovastatin. And that lovastatin went through the drug clinical process and was eventually approved as a drug as Mevacor. When that happened, some of the red rice yeast companies were sort of amping up. They were adding, lovastatin to their red rice yeast. Say, well, now with extra lovastatin. And there's a big case involving a company called Pharmanex, and it went through several years of litigation with wins and losses on Pharmanex side and also on the FDA side, where the FDA said, no, you are violating this drug exclusionary. You're adding an approved drug to a product, and the red rice yeast companies were saying, no, this is a natural constituent of red rice yeast. Lovastatin is part of that brew. The eventual outcome of that case is that naturally occurring lovastatin in a red rice yeast mixture is allowed, but you can't add it to red rice yeast. So it's somewhat of a parallel to our current situation with CBD. And so I think it's pretty clear under that precedent that, say just a squeeze of the hemp bud and it produced, whatever the juices are that happen to contain CBD. To me, that's about as close to a home run as you can get. That's hemp, and it's lawful despite the fact that it contains CBD. But of course, we have all sorts of highly sophisticated extraction and techniques now where we can take all these compounds out and distill them and isolate them and then recombine them in all sorts of different forms and whatnot. And we can take different ratios and different amounts. And so is that similar? So is that the same as a squeeze, or is that more like, the taking this article that was in Epidiolex, or that is Epidiolex, and adding it? And that's an unresolved issue in the law right now. My general sense is that the FDA, and I've written about this in a little more detail, is that the FDA is probably going to, at least for the foreseeable future, not make this distinction. It's probably going to just refer to CBD and let the cards kind of play out as they will, and maybe let the courts, such as in the trademark case, sort of flesh it out for it. So we'll see.
Yes, and nobody really likes to hear that, but that's sort of standard of business, is that until, if something new arises, until it's been decided in the court, it sort of lives in limbo, right? You have a specific interpretation that applies to your exact situation. There's going to be some level of uncertainty, but it is nice to know that there are some precedents out there for natural products of this kind. One thing I always like to point out to folks too is that before this industrial hemp versus cannabis distinction was ever invented, cannabis extract, which likely included CBD, although it may not have been technologically possible to test for the difference between CBD and THC at that time, was broadly marketed as a medicinal product and included in food products prior to the outlawing of marijuana in, I believe, in the 30s, right? So you saw very broad marketing of cannabis extracts of various potencies. And so that sort of precedent of this being a previously marketed product of hemp extracts is pretty strong, at least from my interpretation. Of course, it comes down to the court to make that final determination. But is that something that you see as encouraging as well?
Yeah, no, I think it's very encouraging, and you're absolutely right. I think at one point, cannabis extract was, back in the turn of the century, was one of the most widely recommended or even prescribed medications or ailment helpers that there were out there. And we went to, my family went to Spain on a trip last year, and I was in Barcelona. I took the opportunity to go and visit the cannabis museum, and it's been, it's fascinating to see all of these different sort of tinctures they had collected from the turn of the century, these different sorts of cannabis tinctures. Some of them still had, tincture in them. I don't know that I'd take it now after all these decades, but yeah, no, for sure. I think that does inform the debate and add a lot of credence, to the fact that cannabis is a real medicine. It's not a Trojan horse for, just for, getting high or whatnot. But also it informs this debate about the compounds that are in it, and hemp extract being marketed as a dietary supplement.
Great. Well, I see a question out here talking about THC isomers or CBD isomers, such as Delta 8 THC, Delta 7, Delta 10, mentioning they're not well understood as far as their metabolic interactions with the human body. But from a legal standpoint, what's the legal status of those compounds?
Yeah, well, that's great. Well, so, as an industry, my good friend, Dr. Chris Udala, is talking here, and we've talked about this privately some. How does the industry respond, first of all, to there's 30 different isomers, I think, is that right, Chris? I think Chris informed me, of THC, and there's only a handful, if that many, that we have, historically. He says yes, so great. That we have historically ingested and used. And so while these other compounds or isomers are very, very similar, often there's just the location of the double bond, for instance, might be an issue. They do affect our bodies differently. And as an industry, what is our responsibility? In other words, do we just pump these products out there and hope that they're safe and say, well, that's on the FDA to determine, or do we do safety testing before we release these? And that's an open question as well. I think as an advocate for the industry, on the one hand, I want cannabis and all of its compounds to get out there. I'm a big fan of the minor cannabinoids and alternate cannabinoids. But part of that is responsibility to safety and making sure that not only are they manufactured in a safe way, but that we do some safety studies. When it comes to Delta 8, which is sort of the brand new darling of the industry, fortunately, it appears to be very safe. There are some studies going back to the 70s, having to do actually with children undergoing chemotherapy. So Delta 8 itself appears to be very safe, but that's only one of dozens of these THC analogs. With respect to the legal status, this is fascinating to me. So as I said earlier, based on the source rule, a cannabinoid is lawful or not based on its source. Any cannabinoid from marijuana is a Schedule 1 controlled substance, the most restrictive. In fact, chlorophyll from a marijuana plant is a Schedule 1 controlled substance because the definition says, you know, cannabis and all of its constituent components. On the other hand, cannabinoids and extracts and isomers and derivatives of hemp are all not, or I should say that better, are not controlled substances. And as long as their delta 9 THC concentration does not exceed 0.3%. And so it's really clear that delta 8 THC that's derived from hemp is not a controlled substance, despite the fact that it gets you high, which I'll address in a moment. But the deeper issue is that the plant itself does not tend to express delta 8 THC in any sort of meaningful, certainly not marketable concentrations. And so what tends to happen is you take another cannabinoid such as CBD and you convert it using a catalyst from CBD to delta 8. And so the question is that legal? And my own opinion, and I feel right about this, that's why it's my opinion, and we've spent quite a bit of time analyzing it and debating it and looking at it, is that delta 8 from hemp derived CBD is lawful. It is not a controlled substance. The idea being that you have the hemp plant, it's lawful, it's not a controlled substance. CBD derived from it is by definition not a controlled substance. And importantly, by definition, this is under the statute, hemp-derived CBD is itself hemp. And so that's, in the real practical world, hemp and CBD are two totally different things. But in the statutory definitional world, hemp and CBD are the same thing. And so delta 8 that's derived from CBD is in fact a derivative of hemp. There's some contrary arguments, and I hear a lot about what's called the Federal Analog Act, which says essentially that a compound that is similar in structure to a Schedule 1 or 2 controlled substance and has a substantially similar effect, psychoactive, is also a Schedule 1 controlled substance, even if it's not specifically listed. And that law was enacted primarily to sort of stay on top of all these sort of synthetic designer drugs that come out, that they're not specifically listed, but they have the same effect as, say, cannabinoids or other types of drugs. And people say, oh, well, the Analog Act should control because delta 8 is similar to THC and has similar effect, and so on and so forth. There are several reasons why that's incorrect. The first is because the Controlled Substances Act itself specifically excludes THC in hemp. The second is because the effect of delta 8 is not substantially similar to THC. In fact, most research and my own personal exploration is that it's about, maybe 60% of the effect of THC as far as psychoactivity. So delta 8 is something that I think just a few months ago we were not seeing much of, and then now I get calls every week, if not every day, from that. So I think that's something we're going to see in the market. It's not addressed at the federal level at all, and to my knowledge, at this stage of the game, it's not addressed at all on the state level. But because it has a psychoactive effect, unlike CBD, which does not, at least in terms of impairment, I think we're likely to see some kind of a showdown, certainly some positioning by regulators on delta 8. So that'll be an interesting, it'll be interesting to watch that play out.
Well, and man, there's several branching topics I want to go off of here. I mean, because one thing, like why talk about this when you're making plans about a hemp processing facility, for example? Well, one thing is, this is a potential value-added byproduct pathway. You're going to have THC potentially as part of the extracts that you're manufacturing. A large portion of the market is trending towards remediating that THC, either removing it from the extract in some way or otherwise converting it into something else while still in situ in the extract itself. And so by doing so, you're eliminating this THC that otherwise might make it more difficult to market your ingredient. So delta 8, now maybe it has value as a byproduct, or maybe it can be included in a broader extract after processing that you could market more broadly. So very important to know, is that a valid pathway to move towards your business. Now, one thing that I'm really curious about this, which I'm not sure if anybody really has there's much precedent for it yet, but is this interpretation that you're making on a federal level, what does that look like when we talk about international markets and the potential to export product? If there is a hemp, a hemp extract inclusive ingredient or product that might test positive for Delta 8 THC, do you view that as being a potentially export legal product?
Yeah, good question. So I'll start by saying not at this stage, at least in most circumstances. Of course, it's all country to country. So I'll circle back around and I'll say, as far as the value add, I think you made a really important point, Emmett, and that as the CBD market over the last 18 months has just, the pricing has just done this, then what we're seeing is people using CBD, which used to in and of itself be very high value add and quite very good margins in most markets, and saying, oh, well, if we convert this to Delta 8, it's not super expensive to do, as I understand, but you can really create some value add. And so not only is there market demand, but also a real value. So I think that we're going to see that. The risks are that it's something that the courts haven't ruled on, and so I can sit here and tell you that I've got a great legal theory, and I think that I'm right, and here's why, and everything else. And but the risk is that this is something that's very novel to the market. For the most part, I think that regulators it hasn't hit their desk yet. It's not on their radar. And in many ways, it sort of mimics what we were seeing with CBD several years ago, where people didn't know what it was, and I was pounding on the desk saying, "Oh, CBD from hemp is lawful," and all that worked out. But there were a lot of scuffles and to get to that point. But moving into the international space, most countries have rules where THC is what we would consider a controlled substance. I mean, it's illegal. And various countries obviously have their various rules, but also most countries are participants in one or more treaties, international treaties involving controlled substances, and by and large, these international laws and these treaties don't make these fine distinctions between Delta 8 and Delta 9 and so on. So it's mostly THC. So I think that trading in THC across borders at this point is pretty circumscribed and very specific situations. Now trading and doing international business in CBD is certainly happening, and we're getting lots of calls, particularly about companies that are in the U.S. and wanting to do business and have their CBD or CBD products sold in Europe, and vice versa. The countries wanting to go back and forth, and there are a lot of interesting and intriguing rules that we can discuss. If we have time, I don't want to dominate the conversation and just jump into an international discussion, but certainly when it comes to hemp-derived CBD and CBD products of various sorts, we are seeing lots of international trade.
I'd actually love to go into the international market because I think it's something we haven't been able to touch on much in this series as of yet, and it's a very crucial factor for folks planning their business. But one thing I do want to put a caveat out there. If you are performing a process which chemically changes the constituents of the hemp extract and of cannabinoids in particular, we as an industry need to be very cautious, because there are synthetic cannabinoids out there that have been tested in pharmaceutical trials, early stage clinical trials, that have proven in human studies to be harmful to health and in some cases lethal, right? So up to this point, we haven't had any reports from hemp-derived cannabinoid products leading to any fatalities or really long-term health consequences that are damaging. But that said, when you start playing with reactive chemistry, you start making these compounds into derivative compounds, there's more risk involved. So we just want to urge everybody, of course, be vigilant about testing your products before you bring them to market. Do this in a responsible manner. And we as an industry probably should adopt the common practices in nutritional supplements and new food ingredients, which is to say, go out there, do a clinical marketing study for the safety of your product before you bring it to market. And that way you can market that we've tested this product to be safe for use. We went and we worked with this university or that institution, and they've determined after testing that this is a safe product for human consumption. We've seen some of that out there in the market, but far, far less of that action than in any other major nutritional supplement sector or in any other new food dietary ingredient sector, as you would expect. So I think people are maybe shy on spending the cash. They just want to bring a product to market, try and get to revenue as quickly as possible. But when we look at mainstream business, that's sort of a cost of doing business for most of these other sectors. Do you see trends towards doing those studies? I know we've seen maybe some action on CBD with regards to liver health consequences recently.
Honestly, not a lot, but your point is absolutely right. I mean, that's called R&D, and companies that develop new drugs and new food ingredients, that's a major part of what they do. And not only is it the right thing to do, but frankly, from a legal standpoint, if you don't do that and you just rush to market with a product that ends up hurting people, you're going to be feeling that in the courts for sure.
Right. Yeah, we haven't been seeing rashes of what am I thinking of here? Basically large groups of people getting together to
Class
sue
actions.
companies, class action suits.
Right.
We have seen one or two recently, I believe, although they seem to have gone in the favor of hemp industry. I don't know if you have anything you can point to in terms of what the class action lawsuit landscape looks like out there for hemp right now.
Yeah, it's getting ramped up, and so I think while the news has typically been good, it's not necessarily good in a way that's long-term helpful to the hemp industries. And some of the cases have been stayed based on, meaning that the litigation isn't going forward at this time, based on the fact that the courts say, well, we're going to wait until the FDA regulates it. So we can't make a determination as to whether what you've done or not done in terms of labeling or marketing or what's in the product and so on and so forth was lawful or not, because the FDA itself hasn't come down with the regulation. That's not saying that what they did was right or wrong. And then also with respect to, we've had allegations and there are lawsuits about some of these products containing contaminants, heavy metals and pesticide residue and mycotoxins and so on and so forth. And so that's, while that's separate and distinct from this issue of developing and marketing new cannabinoids, it's crucial and vital that the companies again be manufacturing in CGMP facilities, and that all of those variables are dealt with, because companies can and people can die based on not following these procedures. And with respect to these new cannabinoids, you're absolutely right. I think that cannabis, over history, I think that the number of people that have died from cannabis use, at least directly, is probably zero. And so we think, oh, well, cannabis is safe and this, that, and the other. Well, yes, but you start taking these novel cannabinoids, particularly things that don't typically exist in meaningful concentrations in the plant, and you start isolating them and using them in formulations and putting them out there. We don't necessarily, we can't be totally assured that they're not going to be harmful. And a lot of things can affect that, from the length of the carbon chain on, say, a THC molecule to where the double bond is, and the longer the carbon chain, then the more binding affinity it has to our CB receptors, which means generally speaking, the more this potent it is to us. And it's not necessarily a one-to-one correlation. But the point being that we don't know necessarily what some of these more novel cannabinoids can do, particularly at high concentrations.
Well, I'd like to invite everyone, please send in questions to the Q&A box or the chat. We're getting towards the time period where we usually start focusing on Q&A. In the meantime, while we wait for those questions to roll in, I've definitely got a couple more. One thing I wanted to note while we're on the subject of clinical trials or clinical marketing studies is that I've heard that, or I've been reading about this Valid Care sponsored study into CBD impacts on liver health. And that's a really encouraging thing to me. We're seeing multiple companies coming together. This is including Charlotte's Web Holdings, CB Distillery, Hemp Fusion, Canway, Boulder Botanicals, CBD American Shaman, Columbia Care, a growing list. I think that there's more and more people coming to the table for this, where they're putting in a small amount of capital up front rather than taking on a full study themselves to go after this question of whether CBD has negative impact on liver health, because there was an academic small, a small total group of individuals that were studied, but with some early indications of potential impact on liver health. People question the methodology of that study, but this is going to be an actual clinical study from a legitimate company that specializes in clinical studies for pharmaceutical and nutritional supplement companies. So that's really encouraging, seeing the industry come together instead of acting as individual companies, going across company lines and funding these types of studies. That's what I hope we're going to see in the future for across the board, more and more cannabinoids that we might be using in products, but also other potential impacts that cannabinoids could have on the human body. So that's really exciting news. Love to hear your comment on that. And then maybe I do want to follow up on international markets just to give a little bit more of a taste of what that could look like and opportunities for companies.
Yeah, sure. I think, and I may be able to bridge the gap too. And so, yes, I agree. I think it's important. These tests can be expensive and also, so it helps when companies come together and can all sort of help to foot the bill, but also it helps to take out, an extra layer of potential bias. So, well, our products are safe, and that focus on the marketing piece when companies come together and focus on the cannabinoid itself versus their particular products. I think that's helpful. And the way that kind of bridges over to the international market is the European Union has determined that cannabinoids, and specifically CBD, are subject to the Novel Food Directive. And the Novel Food Directive, which, for those who don't know, is it's defined as a food or ingredient that has not been consumed to any significant degree in the European Union before May 15th of 1997. Novel foods can be newly developed or innovative foods. They can be foods produced using new technologies or processing technologies, or even food that's traditionally consumed on other continents, but not in the European Union. So in January of last year, CBD was entered into the Novel Foods catalog. And the reason that bridges the gap is because in order for a novel food to be marketed in the European Union, it has to be approved. And the primary piece of that approval is a safety study. It's not about efficacy for treating X, Y, or Z. It's about, is this safe? And so what you're seeing are companies that are applying novel foods applications. We're helping several companies with that right now. And we're also seeing companies in many cases getting together and doing some of these clinical studies together for the same reasons, to help shoulder the burden of the costs and the resources that are necessary to do that, and also to it's getting a product to market. In particular, the European Industrial Hemp Association, IHA, is putting together a program so that so its members can sort of buy in into a share, and that they would all sort of participate or benefit from the clinical studies that are being done. It's important to note that currently in all EU countries except for the EU, it's prohibited to market CBD. That doesn't mean that you won't find CBD in Europe. It's everywhere, just like it is here. It's much like with the FDA and CBD in food. It's CBD in food in various European countries is either highly regulated and prohibited, or pretty much allowed, depending on the enforcement priorities of the country at issue. The UK is presents an interesting issue, I should say, because of Brexit. And what the UK has said is that you have until March 31st to file an application. And if you file an application and it's been validated, and we don't get too deep in the weeds on these technical terms, validation essentially means you've filed an application and it's on its face, has all of the necessary components to it. Well, then you can continue to market your products, your CBD products in the UK, pending the final approval of your application, which in many cases could take up to several years. And so companies that are wanting to do business in Europe with their CBD products should be thinking about novel foods. Now, whether you're going to be partnering with a company, a supplier that is approved, their CBD is approved, or whether you want to get approved and maybe be the gatekeeper. Maybe you do processing and manufacturing for a number of U.S. companies who use your ingredient that's been approved and take it to market in Europe. So it's fascinating. It's one more piece of the industry that's unfolding right before our eyes.
Yeah, and that's huge because I know that early on there were requirements for CGMP facilities for hemp extract to be brought to market in Europe. We saw sort of and I think that may have been country by country where they were marketing as a nutritional supplement or a nutraceutical, I guess, in that market, where they had to really bring CGMP on quickly or else be blocked out of the market. It sounds like this is going to actually allow food, including CBD, not just nutritional supplements or nutraceuticals. Is that right?
That's right. That's exactly right. So I think, 5 years from now, we talked about, what's the view in 2025? I think certainly in Europe, we're going to see CBD in food, and we're going to see a lot of companies putting it out there, and probably in the U.S. as well. With some sort of official blessing on some level. But certainly in the European Union, that track has been established, and that's the route that has to be taken to have your food products put on the market.
Does I've heard a lot of people say that European CGMP, if you're going to manufacture CBD oil for export, that's sort of the benchmark that you should aim for. Do you think that's true, that if you're going to try and export to, say, South America or to Asia or Africa, that European CGMP is going to be sufficient to access those markets, or is it a necessity to access those markets?
That's a good question. I've seen, and particularly with respect to South America, that European standards for CGMP do tend to be looked at as the gold standard. And so whether that's going to work on a country by country basis depends on country by country, of course. But I think that if you're trying to sort of have as much global reach as possible, I think manufacturing up to European standards is the way to go.
All right. Well, I see that we have a question from Lejeune from Carbon Chemistry, and he's asking about would you recommend special certification or product labeling for products and companies that use pesticide and heavy metal remediation? Now, I think we should take this question in two parts. One is, do you view removal of heavy metals or confirmation that heavy metals are not present in a product as being essentially a minimum requirement for bringing a product to market? Why don't we start there?
Yeah, I think absolutely. With respect to compounds that can cause harm, they shouldn't be in there, and if they are, they should, at a minimum, should be disclosed. So, is there some special certification or product labeling? I don't think so, because the implication is that your products don't have these heavy metals. From a marketing standpoint, though, and frankly, given some of the press with some companies recently that have been alleged to have products on the market with heavy metals, I think it might not might not hurt you from a marketing standpoint to bring attention to the fact that your products don't have it, and here's why. So hopefully that's responsive to part A of the question.
Right, and from a non-legal perspective, what I would say is that it can't hurt to market your products as being free from heavy metals and pesticides. If you're going to do that, though, make sure that you're doing the appropriate lab testing to validate that your product is free from those compounds. And in particular, I would say with regards to heavy metals, that from a food oils perspective, as well as from a nutritional supplements perspective, the common practice in those markets for ingredient manufacturers is to have a remediation step in the process as a minimum requirement of bringing the product to market. Now, that's less so in specialty oils where you're extracting some very small batch, small volumes, things like potentially olive oil, cold pressed olive oil. Maybe you don't have that, but in any of the large volume production oils, heavy metal remediation is just a part of the step. Same for mycotoxin removal. depth filtration down to submicron for mycotoxin removal. It's just considered best practices to have that included as part of your process line. So we always advocate for that. Carbon chemistry, we've had a working relationship with them for some time. They provide some media, specialty media for those purposes and for the remediation of pesticides. So they're a good option. You can talk to us on an international and national perspective, depending on your scale. We have a variety of vendors to meet those requirements and different technologies. But like Rod was saying, class action lawsuits are starting to become a thing in the market. So if you have heavy metals in your product because you didn't test for them, and you don't have a batch record that you can tie back to prove that you tested for them, well, you might not have a regulatory requirement right now, but the courts are going to come down on the side of the plaintiffs potentially if you don't have proof that you took preventative measures. So that's
I think so. No, I could not agree more. And I also, just as a this term of free, like X, the product is X free, and I think it's important to understand what you mean by when you say something is free of a substance. To how far to the right of the decimal point are you talking about? And I'm seeing this in terms of CBD products that say we're THC free. Well, what does that mean? Is that, first of all, are there other isomers of THC in there? It's just delta 9 THC free, which in a practical standpoint could potentially still have someone pop positive on a drug test, but they bought your product because you advertise as THC free. But also, I think it's important to define what you mean by free, because when it comes to cannabis products, there might be very small amounts, very small concentrations of THC, for instance, but it's there, and so you need to define when you say THC free what that means. So that wasn't exactly the response to that question, but it just reminded me. I think it's important when you're marketing to avoid tripping yourself up by amounting to improper marketing of something.
Right. Yeah. If you're going to say free, you probably want an asterisk that goes to small print that says.
We recommend the asterisk. Yes.
Tested, non-detect at a limit, at a testing limit of whatever ppm. Right. Exactly. Something that's very specific that you're going to put at the very bottom of your packaging.
Yep.
Well, let's see. A follow-up question that I have here is, as far as good marketing practices, we know that the rule of thumb is for consumer products, you're really, as of right now, you should not be marketing with any sort of claims of, as you mentioned earlier, curing, treating, or there's 3 or 4 different
mitigating,
things. Mitigating, right? Any disease or medical condition, which I think includes pretty much any symptom. So anything from pain to sleeplessness to anything like that that could be associated with a condition that might be diagnosable by a medical professional, right? So my question there is, where is the line there for products that include multiple ingredients? And if you're a manufacturer of ingredients, we've seen this on the consumer side. I wonder whether we might not see it on the ingredient side as well, where specific proprietary blends that include ingredients that have gone through clinical marketing trials for nutritional supplement use, or something like menthol, which is I believe sometimes been approved for not the curing of any disease, but for the reduction of pain as a topical application. Where's the line there? If we combine hemp with another ingredient that may have a proven clinical marketing study behind it for a specific application, is it okay to start marketing what that other ingredient has been approved for?
Yeah, there's a fine line. So I guess I'll start by saying, the best thing to do in general is not to make claims. And I still, even to this day, have have back and forth with clients. Well, can we say this? Or what about this? And people are looking for what CBD does. And it's better off if you just allow them to find it, on their own. There's a lot of good stuff, there's a lot of bad stuff, but there's a lot of good stuff out there about what CBD can and can't do. So avoid making claims. The types of marketing phrases that are usually okay is that, may support X, or may, this kind of very loosey-goosey supporting a system or something. But your question specifically about combinations of ingredients, I think is a really good one, because we're beginning to see products that will. I mean, I think menthol specifically, we've got some clients that use menthol. And so menthol is on the monograph, and it is approved for, and I forget off the top of my head, but reduction of moderate pain or whatnot. And so, yes, it's fine if it's a menthol product to do that. The real, where the rubber meets the road though, is what is it that you're marketing? If you have a, Acme CBD, reduces pain, and menthol just happens to be an ingredient. Well, that's probably, it looks like you're marketing CBD as the ingredient that reduces pain. So really, you need to be marketing the menthol as the pain reducing piece, and just hemp extract or CBD would just be an ingredient, not advertised there, because that can cause some confusion with consumers. And I think that's going to get the attention of the FDA and possibly the FTC as well.
And I know this is a whole specialty consulting area and legal area, is just labeling. It's its whole body of work.
Yes, we do it all the time. Well, clients will ask, they'll say, well, so what should we say? And we say, well, we're a law firm. We're not marketers. So why don't you, pitch us? What do you think that, and we can go through and take our red, pen out, so to speak, and circle this and whatnot. But I'll tell you, if you're making claims, mostly what you're going to see from us is a lot of red ink, where we take those things out. So yeah.
Absolutely. I mean, I think one of the hot ones right now that we're seeing, and I do encourage anybody out there, please, questions. We'd love to take any questions that you have.
Yeah, bring them in.
Q&A or the chat panel. But in the meantime, I've got 1,001 questions myself. So, we've seen an uptick in interest in the use of CBN. And I've been seeing some questionable marketing of that product with regards to sleep, and the use of use as a sleep aid, which I know is a pharmaceutical claim. Anything treating insomnia is that's a diagnosable condition, right?
Right.
But how can folks go about reading the medical research literature where you're seeing some indications of what these cannabinoids might have as an effect? How can they take that information and track it towards what is possible to make a claims? You mentioned the monograph. What is the monograph? Is it possible we could get the CBD onto the monograph for specific use cases? Can you explain for us? Because I know that's something that a lot of people lack experience with.
Yeah, well, potentially. So the monograph is something, is a list of chemicals that have been approved for certain types of claims, essentially, just to be real basic in general. And menthol is the classic example. It's something that can help with moderate pain. CBD is I'm not aware of anyone that's sought to have CBD listed on the monograph, but that certainly in the longer sort of course could potentially happen. I think that CBN is a really fascinating case study for a lot of reasons. One is that if it truly is a sleep aid, and I've written about this, I think it would be a game changer. I mean, this takes us completely outside the purview of sort of cannabis and cannabis medicine to the entire sleep industry, which is a multi-billion dollar industry. And there aren't a lot of great sleep aids without that don't have side effects or that work for everybody. And so if CBN can prove to be, something that really does promote sleep with minimal, if any, side effects, well, then you can imagine that market. The problem is that, and to your, you implied this, Emmett, is that the studies are mixed about whether CBN really does, a function as a sleep aid, which from a legal standpoint brings up a lot of issues. So CBN itself is not subject to the drug exclusionary rule, to go back to the beginning of our conversation, because it's not been the subject of clinical trials. It's actually been marketed. And so it can be marketed out, as a, for something that we can we consume. But the problem with marketing, you say, okay, well, that's great. So that means that we can promote it, for sleep. Well, as you indicate, depending on how you market it, you might be marketing it as mitigating, preventing, curing a disease, something that can be diagnosed. Well, at that point, you're in the realm of having an unapproved drug, which is prohibited. But you might be able to make softer types of claims, may promote occasional, relief from fatigue or something, I'm just off the top of my head. But even that type of sort of vague claim is still going to be viewed by the FTC as being a false claim unless you have some data to back that up. So where, to go back to your point about clinical studies, where are your clinical studies to show that CBN at these concentrations is not only safe, but also effective for what you're claiming it to be effective for? So I think we're going to see CBN hit the market in a big way over the next couple of years, but it will be interesting to see whether or not it really gains traction. Is it really helping people sleep? And B, are people going to promotion of it as a sleep aid and helping with insomnia? And unless there's the clinical data to back it, that's an improper claim.
Right, and that's so key point there is, we view like the monograph as, with menthol being an example. These are things that any company can go out there, as long as they're using that ingredient and including it as the active ingredient or an active ingredient in their product, they can make the associated approved claim from the monograph. Now there's a separate track, which is what you're indicating with CBN, which is you perform a study to prove that the specific ingredient that you're using in your product has a measurable effect that is not treating a disease or a diagnosable condition, right? But is some other effect. Vitamins would be a common one, improves X type of health, right? But you have to have data to back that up. So that's where the clinical marketing study comes in. Now, when you go to supply side west, supply side east, or Expo West, Expo East is a big natural products conferences with thousands of companies that happen every year. What you're seeing is a rise in these things like ashwagandha 1, 2, 3, 4, 5, right? Or reishi extract, 5, 6, 7, 9, 8. So the rise of ingredients that are a specific varietal of a natural type of plant or fungus or other type of feedstock, and specific methodology to create an ingredient from that source, and then a clinical study associated with that. And my interpretation in speaking with those folks is that the reason that you're seeing that happen is that that's a specific company creating a proprietary ingredient that they're getting a clinical study done. So they're funding this clinical marketing study that's going to prove some sort of effect that's not a pharmaceutical effect. And then they are going to then be able to market that ingredient as a wholesale ingredient manufacturer to end user products manufacturers, so that they can put it on their label that they use this specific ingredient and make the associated claim on the label. I haven't seen that at all in hemp yet, but as a strategy, it's gaining a lot of steam out there in natural products ingredients overall, especially in the nutritional supplement side, but also somewhat in the food side as well, where you see especially sweeteners that are name brand specific sweeteners that have a specific study that says it creates sweetness of X amount as compared to sugar, for example. So that's I think that's a viable track. We might see that with CBN, but it also, key thing to remember there is that is a supply chain control driven strategy. And you got to know, again, it's typically comes from the varietal of the plant, the process which was used to refine it, and then associate that with the clinical study. And then you have a defensible ingredient in the marketplace that your specific buyers can make a claim, but that's not transferable to other companies. Whereas the monograph, once it's on the monograph, as an industry, we all benefit from being able to make that specific claim. Is that a fair summary of the sort of different strategies?
You ought to take that on the road, Emmett. That was fantastic. It's a great explanation, and I think that we're all going to see some traction with that, with hemp-based compounds, the reason we haven't is just frankly, we're a new industry. You know, the 2014 Farm Bill, it was the first time since the 30s that cannabis has been removed from the Controlled Substances Act. So we're just in our infancy. So for sure, you know, if we're having this conversation 10 years from now, we'll be able to look back and see these developments.
Right, and you know, I got this information in helping to formulate some products out there, so had to dive into the labeling issues and everything, and try and source detailed ingredients for a variety of formulations. And we actually talked to a provider, an academic institution, research institution, about going through these clinicals. The big surprise to me is, you know, their range, depending on what you're trying to prove, this can range from hundreds of thousands of dollars, you know, in the low end, up to millions of dollars, depending on how specific the claims and with what degree of confidence you need to make those claims. So at the level of millions of dollars, I think that's where people's minds go to, that's, you know, that's the bar for pharmaceuticals, and millions of dollars for clinical studies, sort of bottom line. But in the nutritional supplements world, which we're hoping, again, that FDA is going to allow CBD to be used in nutritional supplements, but there's less of a barrier for non-CBD hemp-derived ingredients. It's possible that it could just be a matter of hundreds of thousands of dollars to do one of these clinical marketing studies, which, you know, that's a lower burden for some of the larger hemp companies out there that have, you know, millions of dollars of revenue on a yearly basis.
Right, and I think that, you know, another piece of this is you're talking that I think is driving, or maybe the better way to say is not driving the you know, going and doing these types of testings, aside from the fact that the industry is in its infancy, is that, you know, so far, you know, just having CBD as an ingredient has been sufficient. You know, why invest hundreds of thousands of dollars when you don't need to? But those days are also, I think, coming to a close as well. And so I think you are going to see companies that do have this revenue and these resources to be able to distinguish themselves are going to be start making those moves. And frankly, I think, you know, several thousand CBD companies entered the market in 2019 alone. Most of them were small startups, you know, like you talked about, farmers market type productions. They're nowhere near having the resources to do this type of thing. And I love that, you know, that market and the sort of the entrepreneurship. But those days are difficult. They're getting more difficult, you know, as big companies, dietary supplement type companies with the resources to do these studies are moving into the market, and add COVID and the general cannabis shakeout that's happened in the market that started before COVID. I think, you know, this time next year, this time 2 years from now, we're going to see an entirely different landscape. And that's going to be fewer companies, more resources, and more of this sort of strategy that parallels other natural products.
Big key thing that I see, I mean, I love seeing the mom and pops of the world thriving with hemp products that they can literally market at a farmer's market or otherwise bring to market on a small scale. The big thing to remember with as a processing company is that the bigger a market that you can make for yourself, the better. Vertically integrated companies, they're going to have a very narrow band of, you know, they want to get a clinical marketing study for their product or potentially for their ingredient that they're only going to use themselves. So they're going to try and get first to market advantage with those claims making capabilities. But as an ingredient wholesaler, as a manufacturer of ingredients, you want to build as big a platform for yourself, bigger a consumer base for yourself as possible. So going down this path as not as a consumer products manufacturer, but as an ingredients manufacturer, and getting these clinical marketing studies done for your products could really open up the possibilities for some of these small, you know, small product manufacturers, mom and pop shops, to buy your ingredient, incorporate it into their products, and be able to make those claims at the, you know, at the ground level. Now they need legal advice to make sure that their packaging is compliant, just like everybody else.
Right.
But you can help them to gain access to market, and I really hope that the ingredient manufacturers are going to start to take that initiative, so that we don't see, you know, essentially a lockout of the best marketing strategies just being held by the vertically integrated companies. But, you know, big ingredient manufacturers can benefit the little consumer product manufacturers by taking some of these steps.
Yeah, it's symbiotic. They can, one processor might have a dozen or 100 or whatever, depending how big they are, smaller clients that they're producing their ingredients or their formulations for, and it serves them, and then that enables these, the smaller mom and pops to continue to thrive, which I'm a big fan of and proponent of. But they need to thrive in the right environment where their ingredients are properly sourced and properly created, and where the claims that they make are substantiated.
All right. Well, we have sort of 5 minutes left here. Any last questions? We've got a preeminent hemp and cannabis attorney here. I would think that the questions would be pouring in, but we have a little bit of a quiet audience. Maybe I'll throw it out to you, Rod. Is there any specific news or interesting things on the horizon that you think people should be paying attention to?
Yeah, I mean, I think the thing that on the horizon to be paying attention to is this shakeout that I alluded to earlier. So the cannabis industry prior to COVID, we saw maybe starting third quarter of 2019 across the sectors, whether it be, all the way down to the mall, we're starting to see some financial difficulties. The sands were shifting, and then COVID came in and completely changed the landscape. And so what we're seeing is companies that are maybe having a more difficult time getting their shelf products being sold, but the direct to consumer onlines are growing. A lot of these companies don't have a lot of resources and are struggling to sort of maintain, hoping that the market will have a turnaround and an uptick in the fall. And so, but what I think by and large we're going to see is, at least at the medium to large scale size of the cannabis industry, we're going to have a new underlying ownership structure of a lot of companies. There's several Chapter 11 bankruptcies right now with processors. Some of the biggest processors in the country are in Chapter 11 bankruptcy, and we've seen wholesale sales of their assets. We've seen reorganizations where they're selling off lots of inventory and moving in. So I think we're going to have price fluctuation, mostly downward, with respect to certainly CBD. We're going to have a lot of new capital and new management and a lot of processing and manufacturing companies. And I think we're going to see a consolidation of the market and over the next 18 months. And so it can be a really good opportunity if you can get your resources together, get your capital together to go out and really take a piece of the market, whether it be by buying up assets and inventory on the cheap and plugging it into your structure, or whether it be that you see the field of play sort of opening up for you. Now is the time to really strategize and move forward with it. The industry started here, and we're moving into a whole new direction. That combined with the market pressure from the international industry, and the hemp industry is rapidly becoming international. It's going to be a whole new landscape. Efficiencies are important. Making sure all your legal ducks in a row are important, but also making sure that you're running a company that's focused on what it does and what it does best is going to be important. What I'll tell clients a lot, because this industry brings in passionate people. I'm one of those people. Emmett, you're one of those people. My guess is that most or all the listeners here are passionate about cannabis and cannabis compounds. But the downside to that is a lot of times I want to do everything, or I've got 5 different great ideas and they're wonderful. That all 5 ideas may be great, but I've seen a lot of paralysis happen with companies and people who want to go in and do it all. And I just don't think that that's going to be a sustainable model going forward with this consolidation and resource and asset intensive environment. I think you're going to have to identify what is our 1 or 2 core strengths and go with that. And over time, you may be able to branch out. But if you go out and say, we're gonna eat the whole buffet in one go, you may go. So that's my, shooting from the hip sort of, view of what's going to be happening over the next 18 months and maybe how to think about moving forward.
Well, thank you so much for joining us, Rod. One last thought on that is that, there's going to be a temptation out there to pick up equipment, used equipment from some of these big liquidations cheap and go to market with the same strategy that others have already failed with. We always like to encourage people to remember that operating expense is going to drive your marginal cost. Operating expense is going to be everything as far as whether you're going to be profitable or whether you're going to not be profitable, after you get up and running. So we like to help people, whether they have some equipment on hand or whether they just know what the goals they are trying to set are for their company. We do like companies that have very specific, discrete goals, a good go-to-market strategy that we can help build the right infrastructure for. But remember, overall, operating expense over anything is going to dictate your success as this consolidation happens, scale goes up, and these big players are able to really bring the price down, bring their profit margins down in order to gain large market share. So thank you, Rod, again, for everything that you've spoke with us about today. We look forward to hopefully being able to speak with you again in the future on Plants to Plants as the seasons roll on. And thank you, everyone, for joining us. This is our last episode of the season. Please stay tuned to our Instagram, to Facebook, and to our website. We will have news about season 2 coming out over the next few weeks. And please, Rod, what's the best website to find for you if they're seeking legal advice?
Yeah, thanks, Emmett. The website is cannabusiness.law. Again, I'm Rod Kight, and you can reach me directly, rod@cannabusiness.law or 828-255-9881. Emmett, thank you and the whole Sci-Fi team for having me. It's always a pleasure talking with you. I always learn something new when I speak with you and enjoy it immensely. And thanks for everyone who tuned in. I hope that you found this informative and fun.
All right, thank you, everyone. And we look forward to speaking with you again in the future. Have a great week, end of the week and weekend, and we will see you in a few weeks. All the best.